A myth about evidence in criminal cases is that sometimes there's a lot of it in your case. When you get into be an attorney and you start reviewing cases, sometimes it's shocking how little evidence the police actually do have against people. We'll see situations where there's a police report and that's it. And the police report is 3 sentences. You really think about it, let's say that a police officer gets called out to a scene and they go and they talk to one person and they talk to the other and then they make an arrest. That's the extent of the investigation. It's not like TV and movies where there's follow-up and there's weeks of interrogations and things like that on most cases. So one of the big misconceptions is there's a lot of evidence in cases. A lot of times there's not much against you. The 2 biggest mistakes that we see with people is, one, they get themselves into further trouble because they start talking to the police about their case. Again, it's human nature to want to try to talk yourself out of trouble or, defend yourself if somebody's making an accusation against you. But most of the time, the police have already made up their mind. You're gonna be arrested, you're gonna be charged. The only thing you're doing is possibly opening yourself up to further trouble. The other mistake that we see the most of is social media and cell phones. Everybody has everything documented on their cell phones these days, and for some reason, people are willing to give over their cell phones and give consent to searches on cell phones. At that point, the police have everything that you've been doing for months, if not years, and they use that against you in court. So the misconception about minor charges is that they won't have too big an effect on your future. And with situations like that, you're not so much worried about the case itself. You're more worried about the collateral consequences. What are the things that are going to happen, not necessarily in the courtroom on your case, but things that are going to happen down the line? So, for example, you may have a minor theft case. But it's not going to be a minor theft case 5 years down the line when you're trying to get a promotion and they run your background check and you have a theft conviction on your record. Same thing with like a minor drug charge. You might think, well, it's not that big of a deal. I'm young, it'll go away or something like that. But it's going to be a deal later when you're trying to get loans for education or housing or licensing from the state. So the biggest mistake we have is when clients take small cases and they don't handle them correctly, and they may get by in the moment, but it's those collateral consequences that pop up years, if not decades down the line, that really end up having the worst effect on them. So I used to work for a judge that would tell me that there's a lot of people in prison because of what one person said. And that's actually very true. It usually comes down to the credibility of the person that's making the accusation against you. For example, if the Pope walks into the courtroom in their Pope outfit and says, I saw that person break into a car, you're probably going to be in trouble. You're probably going to get convicted because of the high credibility of that one witness. Fortunately for most of us, the Pope is not out there accusing us of things, and most witnesses do have issues. They have credibility issues, they got motives, they got reasons to be untruthful. And so while one witness is enough to be convicted, good attorneys are going to find those credibility issues that are help provide you a defense that you need. So when cases turn into a he said, she said kind of situation, it always comes down to the credibility of the witness. You have somebody who is a sparkling clean background and they have no reason to be unjust or not tell the truth, and that person may be given a higher level of credibility than somebody who has lots of reasons, lots of motives, lots of reasons to try to get you in trouble or try to put you behind bars, or maybe they're using it against you in a custody case or a family law situation. And so it's always going to come down in he said, she said cases to that witness's credibility. So self-defense is the most commonly used defense in assault cases in Texas. There's a couple misconceptions about it. The way I used to explain it to our jurors is this. Let's say that you got guy A and guy B in the bar, right? And they're jawing each other, and then guy A decides to push guy B. Can guy B push him back? Absolutely. I think that's a classic self-defense claim. The response from guy B is both immediate and proportionate, and those are really the 2 key elements in a self-defense claim. Let's take that same example, right? Guy A pushes guy B, but then guy B goes out to his car, and then his friends start clowning on him and telling him, I can't believe you let guy A do that to you. And so guy B walks back into the bar 10 minutes later and goes and pushes guy A. Does guy B have a self-defense claim? I don't think so, right? Because it wasn't an immediate response. He had time to think about it. He went out to his car. car, and then he made a decision. So in that situation, what you really have is two different assaults. You have guy A assaulting guy B, and then you have 10 minutes later, guy B assaulting guy A. Let's take another scenario, guy A, guy B. Guy A pushes guy B goes out to his car, comes back with a gun and shoots guy A dead. Do you have a self-defense claim there? You don't, because that response is not proportionate, right? It's not a reasonable thing to do to shoot somebody after they push you in a bar, right? So with self-defense claims, while they can be very effective in a lot of situations, courts are going to look at two things. Was your response, was your self-defense claim, was it immediate and was it proportionate? So there are a lot of misconceptions when it comes to court. Bottom line is the best attorneys get the best outcomes for their clients. So again, this is not a time to hire a divorce attorney or a personal injury lawyer that does a little criminal defense on the side. Make sure to protect yourself, protect your rights. Hire a criminal defense firm like ours that does nothing but criminal defense.